let's start with individuals. There are three chapters under which individuals typically file: 7, 11, and 13. There is chapter 12, but in this part of the country, we don't get any of those. That's for family farmers and family commercial fishing operations. And in the Central District of California, that just doesn't happen. So we've got 7, 11, and 13. Now, in a 7, the individual gets to erase debts in one fell swoop. The whole process is typically a short process, maybe 5 to 6 months, and off the debtor sails into the future debt-free, or as much debt-free as possible. However, if the debtor has too much income in a way that can be made precise, the debtor is ineligible for a Chapter 7. Or if the debtor has a lot of non-exempt assets, those are assets that we can't exempt using the appropriate exemption table, then those are on the chopping block, and the Chapter 7 trustee assigned to the case will seize and liquidate them. Well, that may be an unattractive option for an individual or legally married couple. So Chapter 7 isn't for everybody. For those that do qualify and for whom the Chapter 7 makes sense, it's a very attractive option. If your income is too high, the next is Chapter 13. Now, Chapter 13 is, I like to think of it as Chapter 11 light. It's much less complicated than Chapter 11, and it's concomitantly less expensive. It does involve a plan of reorganization where the debtor proposes to pay some portion of the debts over typically a 5-year period. If the debtor's income is below the median, it can be a 3-year period, although most below median income debtors are going to be in Chapter 7, unless they've got non-exempt assets they don't want to lose. But anyway, it can be very manageable. There still is that paternalistic patina over the whole thing. The debtor wants to go buy a car. Oh, can't do it without the judge's permission. Wants to change the terms of the plan because maybe there's been a diminution in income. Can't do it without the judge's permission. So in both Chapter 13 and Chapter 11, there is that court oversight that at least some people complain is paternalistic. But as I said a little bit ago, Chapter 13 does have some debt ceilings. There's a secured debt ceiling and an unsecured debt ceiling, and they're going to change in the not too distant future. So I don't know that it makes sense to give those dollar amounts today. In any event, if you violate either the secured debt ceiling or the unsecured debt ceiling, you're ineligible to do a Chapter 13, and that's when we put somebody into a Chapter 11. Chapter 11 is much more complicated than Chapter 13, and as a result, it does cost more because there's a lot more that the attorney has to do. So it's not for everybody. But for those that are good candidates for Chapter 11, it can be a very powerful tool. Now, what about businesses? Well, businesses don't have Chapter 13 available to them. They can either file under Chapter 7 or Chapter 11. And if they do a Chapter 7, the business is going out of business. All of its assets are going to be liquidated by the Chapter 7 trustee appointed to the case, and the proceeds will be used to pay the creditors. So that's a pretty extreme bit of relief from the business's point of view. It's suicide in essence. There is the additional complication that if the principals are personally liable on those debts, then if after the liquidation those debts have not been paid in full, the principals may be liable for the unpaid portion. So that's not the best route for every business, but it can make some sense if the principals have no personal liability, and there are assets to be liquidated, and they don't want to have the headache of liquidating the assets and paying out the claims. Then there is, of course, Chapter 11. As I said earlier, it's the most complicated chapter of the Bankruptcy Code, but it can be very useful in developing a plan of reorganization that ensures that as the business marches into the future, it can succeed. Well, those are the chapters available in the Bankruptcy Code, and sometimes bankruptcy isn't the right option for either the individual or the business. What happens then? Well, Sometimes the individual only, let's say you have an individual who only has one creditor, and that individual owes a lot of money to that creditor, and that individual did a prior Chapter 7, let's say 3 or 4 years ago, and is ineligible to do another one. Or maybe not enough time has passed so that the debtor, of course, could file the 13, but if you have the 13 filed less than 4 years after you filed the prior Chapter 7, you're ineligible to get a Chapter 13 discharge. You can still go through the 13 and go through the plan, but at the end of the plan, if you don't pay the debt in full, you're not getting a discharge and you'll still owe that money. So another option can be simple negotiations with the creditor. Now, negotiations start to break down if either you have a lot of creditors or you have some really valuable assets that make the creditor decide that you can afford to pay more than what you're proposing. So when I've done negotiations of this sort, I have presented the creditor with some compelling facts. Typically, I'll say, look, my client is a good candidate for a Chapter 7 bankruptcy. My client doesn't want to go through a Chapter 7 bankruptcy, and so we'd like to work something out so that you get paid something, because if you force my client into Chapter 7, you're going to get nothing. That's a fairly compelling argument, and so I've been able to get good results for clients if they have one big creditor. The drawback, however, is if you have lots of creditors, then one of the problems is what's called the free rider problem. Each creditor wants the other creditors to take the bath, and it gets paid in full. That can be a bit of a challenge. And especially if you have lots of creditors, you're going to have to do it one creditor at a time. Well, now bankruptcy starts to make a great deal of sense because you streamline the whole process and you don't have to do it one creditor at a time. The other has to do with the credibility of the threat. If you have had a prior Chapter 7, let's say, in under 8 years, then you can't do another Chapter 7. If the creditor does a little investigation and sees that, then the Chapter 7 is a bit of a hollow threat. Also, if you've got some valuable assets, well, the creditor may say, no, you have the resources to pay me in full. Now, in California, where I practice, the homestead exemption was just increased January 1st. So for people who are in the Los Angeles area or Orange County, the homestead exemption with a couple of caveats is up to $600,000. So if you do a Chapter 7, unless you've got a boatload of equity, the house is protected. But if you're doing negotiations with a creditor and you say, look, I can't pay in full, would you reduce it, say, by 50%? And they see you've got $400,000 worth of equity in the house, well, they'll say, just take out a second mortgage and pay me in full. You might say, well, wait a minute, that's all exempt equity there. So what? You have the resources to pay me, the creditor will say. Go ahead and take out that mortgage and pay me. I'm not going to accept less than what you're proposing because you do have the resources to pay me. So negotiations can be a bit of a problem there unless you have the right set of facts. Similar sort of analysis goes into the negotiations for a business, and I've certainly done that as well. In fact, I remember this one business, it was a shoe company. They were selling shoes. Okay, well, as the owner put it, shoes are like fish. They don't last that long. They start to smell bad because the fashions change so rapidly. And this particular client was producing women's shoes. I think men's shoes, the fashions don't change quite as rapidly, but with women's shoes, if you have old styles, they lose their luster in the marketplace. So this business had a particularly large debt to one creditor. And so I contacted the creditor. I laid out the resources that the business had, the inventory that the business had, the likelihood of being able to sell this inventory, what the other assets were, the likelihood of going into Chapter 7, what the creditor would get in that Chapter 7. And as a result, the creditor came around and said, you know, you're right, we'll accept what you're proposing. And so we greatly reduced the debt. So that can be another option. While I think bankruptcy is the most powerful tool because you've got the power of the United States federal government behind you to force your creditors to accept what you're proposing, on the other hand, there are times where being outside of bankruptcy and doing some sort of negotiated settlement can make a lot of sense.